Okay, so that leads to a related question, the area of Medicaid. You know, we've had a number of clients who've have created Medicaid Asset Protection Trust, have done additional VA planning with us. So let's talk a little bit about what we're seeing in terms of problems that sometimes get created by that, some missteps that we see made that are costing clients some time and therefore some money. So Jerry, Kathy, you want to lead into that?
Yeah, unlike the revocable trust that we have done for you all in the past, and we encourage you all to come in every 3 to 5 years for a review, these special types of trusts, Medicaid Asset Protection Trust, we're asking that you come in on an annual basis, and we're sending those letters out pretty quickly. We want you to come in annually so we can look at the assets and make sure they're still properly positioned, so that doesn't jeopardize the 5-year look-back rule of that trust. When we set this trust up and we fund them, we have to fund them properly, and it's like taking a snapshot to get you to qualify. So it's a real touchy area, it's a real complicated area. Position of the assets is really tricky. He can go into some of the problems that we've had with some of them in the past and are currently dealing with right now, whether it be the banks not responding to our requests, or whether it be the people just not understanding about direct deposit accounts. That's why it's important that we keep in touch with you and you keep in touch with us on an annual basis so we can keep all that intact. We'll discuss some situations.
So go back to the beginning and explain to us why someone might want to even set one of these up in the first place.
Well, that's a good question. If, you know, people have worked hard and worked hard and worked hard for their assets, and then if we don't do proper planning, and maybe a couple have maybe a couple $100,000, and one of them winds up in a nursing home, and they don't do proper planning, and they're in that nursing home for several years, that could leave that surviving spouse destitute with no assets at all. This is kind of a way of trying to look ahead and preserve those assets and do some pre-planning to preserve the estate for their surviving spouse and or the kids. It just depends on the situation.
So when you set up what we call a Medicaid Asset Protection Trust, do you have to put all of your assets into it?
Not all of them, no. It depends on what we want to protect. We want to make sure we don't disqualify you. And so he can talk about that, but there's some assets that we do not put in that trust.
Okay.
And one of the things that we tell everybody is if you set up one of these trusts and you've got a checking account that your retirement comes into or your Social Security comes into, you don't want that in the trust, because then the 5-year rule says if we set up one of these protected trusts and we fund it today and we don't add anything to it, it can generate its own income, but we're not adding anything to it, 5 years down the road, all of those assets are now sheltered and the state cannot touch them, and we can qualify ourselves for benefits as well. But if I add assets to it, I restart that 5-year all over again. Well, we had a client that set up a trust 18 months ago, at the time we saw him. He had notified his bank to put his savings account in the trust, keep his checking account separate. But he didn't follow through. The bank put the checking account into the trust as well, so he lost 18 months of time on qualifying for eligibility. I had another client just contact me last week. She set up her trust 8 years ago, so we're protected. She wants to sell her home and buy a home closer to her son. She's still living semi-independently, but she needs to be closer. The new home is going to be more expensive. And she thought, well, I'll sell the old home, I'll take that money, put a down payment on the new home, and then I'll use my income to make the payments on that house. And we said, no, because every time you make a payment on that new house, what have you done? You started that 5-year clock all over again. So you need to take that home, and you need to take some money out of savings to buy the new house and not add more money to the trust. You have to understand, Medicaid is a federal-state partnership program. So we have federal laws, but we also have state laws, and the states are given some discretion on which federal laws they follow and which ones they don't. Then we have the Oklahoma Administrative Code, which are rules promulgated in support of that law, and those can be changed without any legislative action. Then we have the Director of the Department of Human Services and the Director of the Oklahoma Healthcare Authority who have the power to modify policy. And then you have county supervisors, and you have senior social workers. And so we don't know what those rules are. And the rules in effect when you set up that trust 3 years ago may not be the rules we're playing with today, and we need to be sure that we tweak that trust if need be to stay in compliance with the law. Does that make sense? So we want you to come in for two reasons. One, let's make sure that the banks and the other institutions did what they were required to do. Number two, that the law hasn't affected you in some way that we need to fix, and that we continue moving towards that entitlement. And once we get that 5-year lock-in done, that we don't do anything that then reopens Pandora's box.
So the reason this comes up is because many of us, when we were younger, having had the opportunity to purchase long-term health care insurance, did not, and therefore were exposed to the cost of nursing homes if that were to happen to us. And you may have seen the article in the paper not long ago, the 10th of April. Elder care costs climb, nursing home bill $91,000. Now, that's a national average. Fortunately, we're below that.
But not much.
Not much. A little over 60. I mean, that's a third lower. But still, if you think about $5,000, $6,000 a month in after-tax income and a 4-year stay, you can eat through significant assets pretty quickly. So that's why all this is coming up as all of us, get to a certain point in life where all these issues become much more important. So, anything else on that point?
I'm sorry. I was going to say I have a quick question. So my understanding is this is an irrevocable trust?
Correct.
Okay, so what happens if we set one up, we fund it, however you advise to fund it, but then we never have the need for long-term care? What happens to those assets?
It works just like a revocable trust. It's actually easier to administer because, in essence, the assets are already over in the kids' names. We just have a right of income and a right of control. So when something happens, it's pretty simple. We file a death certificate and we distribute.
Think about it from their point of view. So when you say right to income and right to control, so even though the trust is irrevocable, who gets to serve as trustee?
They can be their own trustee.
Client can be the trustee.
Client can be the trustee. Client can change beneficiaries. Client can change trustees. And through the Trust Protector Clause, the trust itself can be modified if situations change or laws change. So there's a lot of flexibility. Even though it's an irrevocable trust, in many senses it looks like a revocable trust because we have that client control.
And who has the right to the income?
The clients.
Okay. And does that last throughout their entire lifetime?
Depending upon whether they set it up as an income trust or a discretionary trust. But that's a decision we have.
Is there a point at which they would no longer be able to serve as trustee?
Only if they were to enter into a long-term care situation where we need to segregate those two duties.
And at that point, then their selected trustee of choice would step up and take over bill paying and so forth.
Correct.
And as a practical matter, when that happens, do people want to really keep paying the bills at that point anyway?
No.
Probably not. So, okay.
But again, there are some trusts, Medicaid trusts, where you're not your own trustee. He drives me crazy because he goes this direction on Monday and he goes this direction on Wednesday. So everybody's situation is different. So there's no two Medicaid Asset Protection Trusts alike. Depends on the circumstances, depends on the law, depends on what kind of email or feedback we get from the state. So it's just an ever-evolving planning session that we have at least once a week.
What if competency becomes an issue?
Do what?
Competency, if that becomes an issue.
Well, and that's why we have the Trust Protector Clause, so that we can, even if that person's incompetent, we can make the necessary corrections. But think about it, if we're on a VA plan, we have to go one direction. If we're going to Medicaid plan, we're going another direction. If we're going to VA/Medicaid plan, we've got to go a different direction. So it's not one size fits all. It's what are your facts, what is the background, what direction do we go? And then the other thing, and I tell everybody, I'm a chicken. So before we ever put pen to paper, I contact the legal department at DHS, and I say, okay, this is what we're doing. Does this work today? It worked yesterday. Does it work today? And if he says yes, then we implement it. A few times he's come back and said, no, Jerry, you can't do that anymore. The rules have changed. Now you got to do this. And they don't tell us when the rules change. That's all internal. So the only way we find out about that is by, there's 23 elder law attorneys in the state, and we all talk almost daily, because that's the only way we know what changes are coming about. And then we talk to the legal counsel there, and he tells us what's going on. So we don't implement anything unless we know that on the day we implement it, it's going to work.
And it can vary county by county.
And county by county.
Tough area.